man accused of kicking down a door and fleeing on foot. This must be some kind of SNL skit, right? Or maybe like an Onion article? Not quite. Instead, for Charles Reed, this was a real arrest, a real, albeit partial, jail booking, and a real legal nightmare. Today, by popular demand, aka one single comment on an unrelated video, we're taking a look at a case that defies both logic and basic common sense and the tenets of American constitutional law. The felony assault charges brought against a man who has been in a wheelchair for over 20 years. Hey, I'm America's attorney. I've been a lawyer for as long as Charles Reed has been in a wheelchair. I've helped over 160,000 people, and today we're gonna break this mess down. The story actually starts all the way back in June of 2024 when College Park police received a report from a woman named Catherine Jensen claiming that Charles Reed, a man she hadn't spoken to in nearly 2 decades, had broken into her home just days earlier. According to Jensen's lies, Reed allegedly kicked in her front door, entered the house, assaulted her, and then tried to steal her car keys before fleeing the scene, get this, not a joke, on foot. Police took the report at face value, and despite Jensen's refusal to press charges, that should be a red flag, filed for an arrest warrant and initiated a felony assault case against Reed. Now we fast forward to March of this year. Charles Reed, unaware that he had a warrant out for his arrest, tried to renew his passport and was informed that he did have a warrant. Shocked and confused, he voluntarily went to the College Park Police Department to clear things up after emailing with them for a few weeks. What followed was captured on bodycam footage that has since gone viral and deservedly so. In the footage, Officer Mark Ballot tells Reed he's under arrest for felony assault, despite Reed explaining that he's paralyzed and can't stand. While Officer Ballot is attempting to handcuff Reed, Reed falls from his wheelchair to the ground. He's then left lying on the floor for over 3 minutes while officers discuss what to do. Yes, I wonder what you should do if you knock someone who's a paraplegic out of their chair onto the floor. I mean, I can't imagine what it would be. I'm sure it's written down somewhere. One of the craziest parts of this story, and actually one of the only highlights, is that one of the officers on the body cam understood how ridiculous the arrest and the warrant were.
But we're gonna do our due diligence, because if you're paralyzed, somebody must have made a mistake.
Despite all of the contraindicators, a lieutenant with the department tells the officers to proceed with the arrest, calling Reed's fall a ploy. Actually, he calls it a ruse.
It's a ruse, man.
So,
I mean, it's an obvious attempt to not to go to jail. So
a ruse. I mean, a super long con, right? To spend a quarter of a century in a wheelchair just to get out of one false allegation where the person didn't even want to press charges? Well, luckily, Reed was not booked that day after a transport officer arranged for Reed to be booked at a later date. I mean, maybe he wasn't a threat to society, I don't know. But before that could happen, the story went viral, yay, and the charges against Reed were dropped. But is the dropping of the charges enough? I mean, is that justice? The legal foundation for Charles Reed's arrest hinged entirely on a single witness statement from Catherine Jensen. And not only was it just a witness statement, but it was also untested. The officer didn't ascertain if it were even possible that the things that she said happened could even remotely be true. Under the law, police can seek an arrest warrant if they have probable cause, which is a reasonable belief based on facts and circumstances that a person committed a crime. But in this instance, that belief was based solely on an unverified accusation without any physical evidence, without any witness corroboration or assessment of whether Reed was even physically capable of committing the act, much less a face-to-face interview with Reed. At the time that the arrest warrant was issued, Reed's status as a paraplegic who had been wheelchair-bound for over 2 decades was publicly known and verifiable. Yet officers did not appear to weigh this information before seeking or executing the warrant. And to be clear, it's not like they knew it. I mean, the officer who investigated the allegations, the officer who pretended to investigate the allegations, like I said, he never met with Reed, even though the suspect was never unwilling to meet with him. Moreover, he didn't pull his driver's license or do anything else to find out about it. Legally, while the threshold for probable cause is not particularly high, it still requires more than a facially implausible claim, especially when the accused's physical condition makes the crime essentially impossible. Especially particular details like kicking the door down and fleeing on foot. They also failed to consider the credibility of the accuser, Catherine Jensen, who had a known history of making false reports, including a prior arrest in 2023 for filing one. That information was publicly available and should have been part of any reasonable inquiry before issuing an arrest warrant. To be clear, I'm not saying they shouldn't investigate her claims just because once upon a time she cried wolf, but I'm saying that before they issue an arrest warrant, they should know that she is a documented liar. The percentage of our population that has been arrested for filing a false police report is so
very infinitesimally small.
In the legal context, while officers are not always required to conduct a full-blown investigation before making an arrest, they are expected to act in good faith and not ignore glaring inconsistencies or exculpatory evidence.
I mean, he could have forced entry if he had a tool, or, I mean, who knows? I mean, I don't think just because you're in a wheelchair doesn't mean you
Can't break a door down.
Right.
Huh?
Now, in this situation, they didn't have any exculpatory evidence because they didn't have any evidence at all. I'm not saying that they did their job poorly. I'm saying they didn't do their job. Like, they didn't do it at all. They just didn't show up for work that day. So how could you say they did it poorly? They weren't even there. Now, as of the filming of this video, Reed has regrettably not yet filed a lawsuit against the College Park Police Department, but he definitely has grounds to pursue civil rights lawsuit under 42 USC Section 1983, which allows individuals, for now, to sue government officials for constitutional violations carried out under color of law. To succeed, Reed would need to show that his Fourth Amendment rights were violated through an unlawful arrest or excessive force or a failure to accommodate his disability. I wonder how many of those three things happened to him.
Do me a favor, put your hands out. Unfortunately, it is.
Oh my God! Oh my God! Oh! Do you understand what's happening to me right now? I need a paramedic like immediately.
One of the legal hurdles in such cases, as you know, is the doctrine of qualified immunity, which shields officers from personal liability unless it can be shown that they violated clearly established rights that a reasonable officer would have known. In Reed's case, the body cam footage capturing officers dragging him by the arm and leaving him on the floor for over 3 minutes could be powerful evidence in challenging qualified immunity, especially when paired with the implausibility of the original accusation and the officer's apparent disregard for Reed's disability. If a court finds that no reasonable officer would have believed probable cause existed, or that the treatment Reed endured was excessive under the circumstances, then the immunity defense could fail, opening the door for compensatory damages and potential injunctive relief. I mean, even the College Park police knew that there might be a lawsuit here.
So y'all better get the lawyers on standby because I ain't know. Well, he's gonna make a whole issue out of this.
I'm so glad this interaction was caught on body cam footage because it's so unbelievably stupid that it's kind of hard to believe it's also real. And we just can't have a video that mentions qualified immunity without also talking about the absolutely asinine executive order issued by President Trump on April 28th. And before I make a perfectly reasonable criticism about this executive order, I just want to say this. I know that many of the people who watch my channel are big fans of the president. I don't care. What I'm saying is not about him or about any of his other policies. He's not my hero, and he shouldn't be yours either. He should just be the president. He's not a demagogue.
That's a big word for Elmo.
And so when I point out that the executive order called Strengthening and Unleashing America's Law Enforcement to Pursue Criminals and Protect Innocent Citizens is so un-American and so unconstitutional that I can barely believe it exists, I would encourage you to just think for yourself. I mean, look, I know this is a stretch, but maybe even read the order. Things like using private sector pro bono assistance for law enforcement officers, or seeking enhanced sentences for crimes against law enforcement officers, and providing practices for law enforcement to aggressively police communities are not a step in the right direction for our country. You don't have to be a liberal to not want qualified immunity and sovereign immunity to grow and expand and eventually shield all law enforcement from any real accountability. You don't have to believe me. Just go read the executive order and think for yourself. Obviously, it's super easy to criticize the investigating officer, the one that did the arrest, but even that guy had some misgivings once he met the suspect in person. So I have to turn my attention to the boss, the lieutenant, who was so lazy that he wouldn't take a break from eating pretzels to make sure that his officers weren't making a mistake. It also really bothered me that both the people who came to see him in the video had to apologize for interrupting his lunch like he was some sort of dignitary. Look, Charles Reed didn't do anything wrong, and he didn't deserve to be arrested. The least that this lieutenant could do is get up off of his and find out why his officers were no longer perfectly committed to the execution of the arrest warrant that they had previously sought. It's this sort of laziness and carelessness which causes people to make fun of cops for just eating donuts and getting fat and farting in their cars 24 hours a day.
Oh, dang. This is good bait. 1, 2, 3, 4, 5.
From the questionable decision to issue an arrest warrant based solely on an implausible claim, to the officer's failure to do any sort of meaningful investigation, to the officer's failure to accommodate Reed's disability during the arrest. The situation reflects a breakdown at multiple levels. If someone in Reed's condition can be arrested or dragged from their wheelchair on a charge that defies basic logic, it calls into question the safeguards in place to prevent wrongful arrests more broadly, including me and you. I'd love to know your thoughts on Reed's arrest. Drop your pro se opinion down below in the comments, and while you're down there, don't forget to lawyer up with me, America's attorney, by hitting that subscribe button. Knock it to the floor. And I'll be back soon with more legal breakdowns. You won't want to miss it. See you then. Reed allegedly kicked her in the front door. Whoops. And potentially, okay, sorry. Especially when